Hello, this is Professor Bustillo-Booth, and welcome to our first wrap-up for Management 276 Employment Law. In the next 25 minutes, I will go over main concepts and activities that we went through in the first 2 weeks of class. Now, please be sure to take notes, as there will likely be a quiz that you will take after you watch this video. Let's go ahead and get started. In the next 20 or so minutes, I'm going to go over what we went through in the first 2 weeks of course. First, you went through onboarding steps to help orient you to the learning platforms Canvas and Connect, and you were required to register your book, Employment Law for Business, at the Connect platform so that you can access the learning activities there. In week 2, we dove into Chapter 1, which is Regulation of Employment, and Chapter 2, Employment Law Toolkit. You also conducted a Canvas discussion in order to start diving in, applying the legal concepts that you got from the first 2 chapters. And please be sure to look at the rubric for Canvas discussions so that you can earn maximum points there. The remaining part of this video, I will go over major employment legal concepts and their applications in select Canvas discussion topics. For this video and the remaining videos are on the wrap-ups. The main source that I will be using here is the book that you are required to have, which is the Employment Law for Business, 8th edition, by Bennett, Alexander, and Hartman. There will be other sources that I will be using, and those will also be noted on the slides. Let's begin with talking about why employment regulation is even necessary. In an open market system, one can argue that it is in the best interest of the employer to hire the best candidates and therefore will not consider other characteristics other than their qualifications. However, in an imperfect world, people do not always act rationally and do not always act without prejudice. And so therefore, laws are put in place so that we have equity and fairness. And then in terms of who is subject to regulation, that's where definitions of employee and employer are important. And we'll go over that here in a moment. The origins of employer-employee had its start under the master and servant model. It has evolved to be the agency law, or what is also called law of agency. And basically what that really means is that the employer is seen as the principal and the employee is seen as the agent. And in that model, the employee agent acts only as authorized by the employer. And this authority is usually articulated in the roles and responsibilities of a job description or other communications that then authorizes that employee to act on behalf of the employer. If the employee acts outside of that authority, the employer is actually liable to the third party. The employee, however, is not off the hook and is then liable to the employer for the same amount, right? And so the employer has legal obligation to exercise in good faith. That means that it agrees and promises to act fairly and in just ways towards the employee agent. So that is the sort of the principal concepts within the agency law model. Now, who is an employee and does it really matter? You are not an employee simply because you got paid to do work. The law, employment law, actually looks at certain tests to determine whether or not an employee is an employee. And there are 3 such tests. The common law agency test basically asks whether or not the employer has the right or ability to control the work. The IRS 20-factor test involves, like it sounds, 20 factors to determine whether or not the employee is actually an employee. And these are listed in your book, and I won't go through all of them, but all of these are based on court judgments as to what they mean. So things like training, set hours of work, full-time requirement, and the like. There is also another test called the economic realities test, and it basically asks, is the worker economically dependent on the business? And what the courts look at is not just one of these to determine whether an employee is an employee, but it can use a combination or a fusion of these to determine whether someone actually falls under the legal definition of employee. Now, an interesting case is that of an independent contractor, and that is one who performs under contract a task according to their own methods, the contractor's own methods, not under the principal's control. So the principal or the employer in this case cannot actually dictate what methods can be used to perform that task. So that would be a person or agency that is termed an independent contractor. Now, for legal purposes, an independent contractor is not an employee. Okay, and this is important because Title VII of the Civil Rights Act of 1964 prohibits discrimination against employees, but not independent contractors. So this distinction is important, not only for liability purposes or for compliance purposes, but also for taxation, because independent contractors pay their own taxes, whereas employers pay taxes on their employee. The definition of employer is fairly straightforward: one who employs others to work on their behalf. In general, employment regulation operates under this notion of freedom to contract, where an employee may choose to work or not work for an employer. An employer may choose to hire or not hire an applicant. In general, you do not have a right to your job. There are far more reasons that you can be fired than not. And an employer can fire you for good reason, bad reason, or no reason at all, as long as that reason is not illegal. An employer can fire someone simply because they don't like them, but this reason cannot be based on discrimination. The predominant employment condition for most workers in the US is that of employment at will. This is where there is no contractual obligation to remain an employee-employer relationship. This is where either party can end the relationship with good, bad, or no reason at all, as long as that reason is not illegal. There are exceptions to the employment at will, and one of which is called public policy. And at least 44 states, including Washington, has this exception in the books, where employers cannot legally fire an employee who is exercising their public duty to uphold the law, right? For example, an employee who refuses to lie before the court on behalf of their employer cannot be legally fired, because lying before the court would submit the employee to perjury, which is a criminal act. Another exception is what's called good faith and fair dealing. About a minority of states, about 13 states, not including Washington, recognizes this exception. And it basically says that the implied contractual obligation is to act in good faith in that relationship. So in that case, the parties agree to deal with each other fairly and in good faith to address agreement disputes. The third exception is what's called implied contract. And about 41 states, including Washington, recognizes this exception. And this is where a contract that is not expressed but is created or assured by words or actions of the parties involved. So it's not actually written in the contract that a particular job is protected for particular reasons, or that employee is an employee and has certain contractual rights, but it is suggested and created by certain assurances. So for example, when a supervisor, an employer representative says, we need good employees around here, and you've got a job for life, or we don't dismiss employees without giving them a chance to correct their behavior, those statements may actually imply a contract is at place. And so due process would have to come into effect before someone could be legally let go. or they may not be legally let go because the due process suggests that there is no legal reason for them to be let go. And then another example is that it may appear in the handbooks or practices, policies, or some other written statements that assures that conditions of employment may have been created. So that those conditions of employment are then implied, and a contract would have been created by the nature of the assurance itself. The balance of power between employer and employee can really be challenging. And Congress recognizes that employers often have far more resources and presence in the marketplace than an employee might. And so it has issued employee protections so that there is a balance between employer needs and employee needs. And at the center of that really is this consideration of the public good. And where this might manifest itself, and there are many places this can manifest itself, is in the area of non-compete agreements. And so it's also called the covenant not to compete. And this is an agreement by the employee not to disclose employer confidential information or not to compete with the former employer for a specific time period or a specific region. And it must be reasonable to be enforced. So, for example, it would be an imbalance for the employer to insist that the employee cannot compete with the employer for 10, 20 years or something like that, because that would prevent the employee from perhaps finding a reasonable job, right? Or to be able to support themselves economically. The enforcement and details of these non-compete agreements really vary from state to state, and why it's really important to have something called the forum selection clause, which will identify the state, that law that will then apply to settle contractual disputes. In the case of the scenario that you had to respond to in Canvas discussions, where there was an outside sales representative who had a non-compete agreement, who once worked for a client across states as a sales representative, was then recruited for another company and started calling these customers to start doing her work, and who was served notice that her previous employer had filed a cause of action for breach of a non-compete agreement. And then the question was, what are her strongest defense? And in this case, among the things that NAM would have to look at really is to make sure that the covenant not to compete had a reasonable time period. So if it were over a year, for example, she may have a reasonable argument that says, we can't really enforce this beyond the 1 year or something like that. And the other is to really look at the forum selection clause to see which state law is applicable, because that state law may or may not necessarily be more favorable to her. Another is to argue the point that the client list is available through the public domain, and that she could then generate that list herself, probably because she had really good memory. There were only 60 of them. She developed really good relationships, and that she could generate that list on her own by accessing the public records, for example. So those would be among her strongest defenses. Another example of how the courts really try to balance the needs of the employer and the employee is in another one of the discussion points that you had on Canvas, where the police officer Ron and his wife Megan Dibble needed some extra money, so they decided to charge money for viewing some sexually explicit photographs and on videos of themselves, and they posted this on the internet. And while this was an otherwise legal act, Ron was a police officer. And when his employer found out about it, he was terminated. And you can actually look up this particular case by copy and pasting this into Google. And there's a whole discussion about it because it was a kind of famous case. And then the question is Ron's termination in violation of his right to freedom of expression under the First Amendment? And freedom of expression and freedom of speech are synonymous in this case for the First Amendment. And the court found that, Ron had the right to freedom of speech and expression, he just couldn't also be a police officer, because the bottom line was this diminished his ability to carry out his duties. And so therefore, the police department, had the right to go ahead and terminate him, because Ron Dibble was diminished in his capacity as a police officer to enforce the law, given that his actions pretty much diminished uh, his public integrity and standing as a public servant. And so in this case, the court found for the city of Chandler. Now let's talk about specific employment discrimination concepts. And you may also you hear me say them as legal concepts. In the context of our class, those are going to be synonymous, okay? One of which is this idea of disparate treatment. And it's basically what you probably think about when you think discrimination. And this is overt, it's outright, it's intentional discrimination. And it basically means to treat someone who is similarly situated, right? Maybe have the same job, because of their race, their color, their gender, religion, and etc. And so examples of this would be not hiring women to be police officers, right? That's just outright discrimination, because women can be equally good police officers. Not hiring men to be flight attendants. Not hiring African Americans for supervisory roles. Firing people when they turn 60 years old because you think, oh, they're going to be too old to be able to do the job. That's just outright, overt, intentional discrimination. That's what disparate treatment is to treat an individual based on their particular protected group status, whether it be race, color, gender, religion, and the like. Another employment discrimination concept is one that is actually allowed, and this is the bona fide occupational qualification defense. This is legal discrimination, and it's used by employers in disparate treatment cases to show that the intentional discrimination is actually a business necessity. So examples of this would be things like airline pilots have mandatory retirement age for safety concerns. Or male clothing designers have the legal ability to advertise for male models only, because where female models would be unable to model men's clothing as intended. Churches legally hire only members of their church, because and also reject clergy from other religions. Airline to hire only pilots of a certain religion, because one of the countries that the airline flew over prohibited, under punishment of death, the presence of people outside of this religion. So you don't want decapitated pilots, right? And there are other examples of this. And this one I got from a certain source that you see here at the bottom of this slide. So in the case of a BFOQ, is that one of Wilson versus Southwest Airlines Company. And this is one of your Canvas discussions. And the issue before the court is whether Southwest has proved that being female is a BFOQ, a bona fide occupational qualification, that is reasonably necessary to the normal operation of its particular business. And you may be asking yourself, how would I have known that? Well, because a careful reading of the case would have said exactly that. And issues before the court typically start with the word whether. It is the question they're trying to solve, right, and resolve in order to make a judgment. And so in this case, if you were to put in other words, you could say the issue before the court was, did Southwest Airlines make the case to use female-only flight attendants to qualify for a BFOQ exception? Did they do that? And so what the court did was follow the two-step BFOQ test. And this also is articulated in the case. So again, a careful reading of the case would have allowed you to see precisely what the court did in order to arrive at this judgment. And those two-step BFOQ tests for the court look like this. Does the particular job under consideration require that the worker be of one gender only? And if so, and this is the second step, is the requirement reasonably necessary to the essence of the employer's business? And to both of these questions, the court said no. Males could do the work just as well as the females could, and that Southwest Airlines was in the business of transporting people from one place to another, and that transport of the people from one place to another did not necessarily require that the flight attendants needed to be female only. And so they couldn't, Southwest did not prove its case, and so therefore they couldn't use this policy of hiring female only attendants. Another employment discrimination concept is that of disparate impact or adverse impact. And this is when a seemingly neutral policy, practice, rule, or systems result in statistically significant impact on a protected group. So for example, applicant test results unintentionally eliminate certain minority applicants disproportionately. And how the court figures this out is to provide this rule. It's called the 4/5 or 80% rule. And it uses not only this particular rule, but other statistical analyses and other tools to determine if disparate impact has occurred. And so just for our purposes, so we understand what this sounds like or what this looks like, the federal guideline states this: a selection rate for any race, sex, or ethnic group which is less than 4/5, or the equivalent of 80%, of the rate for the group with the highest rate will generally be regarded by the federal enforcement agencies as evidence for adverse impact. An example of this is, in your screen. So the 80% rule and adverse impact can look like this. So for example, there's a group of non-minority and minority. So we're looking at this particular table right here. And there were 100 applicants for the non-minority group, and there were 50 applicants for the minority group. Of the 100 applicants, there were 20 hires, and that's a hire rate of 20%. Of the 50 applicants, there were 3 hires, and that's a hire rate of 60%. Now 6% of 20, so 6 over 20 here, is 30%, and that is less than the 80%, and so therefore there was adverse impact. Again, there are other statistical tools to figure out to make sure this is actually statistically significant. And so here's another example where there's a group of male and female, and the male applicants, there were 100, 23 hires for a 23% rate. Of the female applicants, there were 80 of them, 16 were hired, 20% higher rate, and 20 of 23% is 87, right? So that meant that it is above the 80% rule, and so there is no adverse impact. Now, the article I had you read about the Target settlement is a good example of a disparate impact situation. In this case, the plaintiffs alleged that Target's criminal record screening policies disparately impacted African American and Latino job applicants. And they had this practice where they assessed ex-offender job applicants as eligible or ineligible for employment, without regard to whether or not those were felony charges, misdemeanor charges, or other lesser offenses. And they may not have been necessarily relevant to the kind of job that they were applying for, right? And it's not that companies cannot have those kinds of screening, it's how they do it and when they do it, and for whether or not they're against a certain kinds of job qualifications. Now, no court has actually ruled against Target, and Target has not admitted any liability. They settled out of court, and they settled in order to have some kind of guidance to change the way they do their screening. So this is called programmatic relief, and also they settled for monetary settlement. And this was to avoid a class action lawsuit across the nation, which would have been incredibly time-consuming and even more costly than the settlement that they had agreed to. All right, that brings us to the end of the first wrap-up. Should you need me to go over some more of the legal concepts, or would like to sit down with me and have a one-on-one to discuss assignments, please do reach out to me by email or arrange an appointment. I am happy to help. Now, after this video, depending on which section you might be in, you may be required to take the wrap-up quiz. So be sure to do that, and good luck. Thank you so much for watching.